Good afternoon, everybody. Thank you so much for joining us today for our latest webinar, Expert Answers to Common Estate Planning Questions. My name is Christy Lawler and I'm the Gifts and Wills Manager here at St. Vincent's Foundation. We are thrilled to have so many wonderful supporters present today, and I thank you all for taking time out of your busy day to join us. So I'd like to acknowledge the traditional custodians of the land on which we meet today and on which many of our sites are located. We pay our respects to elders past and present and welcome all Aboriginal and Torres Strait Islander people to our places of care. Now, a little bit of housekeeping to start things off. The webinar today will run for 30 minutes and it will be recorded and shared with you via an email in the coming days. And if you enjoyed it, please do share it with friends and family. Now, the Q&A option is enabled, but due to time restraints, we may not be able to answer the questions today. I am very confident, though, that any question that you have probably will be answered during this webinar. Now, our guest speakers, I am delighted to introduce our expert speakers to everybody. Many of you will remember Mark Murnane from our previous webinar. Mark is the principal lawyer at Murnane Legal, and the sole focus of his firm is wills and estate planning. He understands the importance of having a well-drafted will, and he knows that his clients spend a lifetime working hard to accumulate their assets, and it is his job to ensure the right people receive those hard-earned assets. Also joining our discussion today is Martin Hegarty from Hester. Now, Martin brings over 15 years of experience in financial services and advice. As a superannuation specialist with Hester, he meets with members to support their knowledge growth and education through both general and limited personal advice. He is also part of a team that delivers group education seminars and workshops to empower individuals to maximize their super and improve their financial literacy. So we're going to get straight into it. So Mark, our first common estate planning question is for you. So what happens if I die without a will?
Very good question, Christy. And this comes up more than you would probably want to see. Effectively, what happens is you're letting the government write the will for you. The government is writing that will for you through legislation. So there's legislation that sets out what happens when someone dies without a will, and is effectively based on your relationships. So those relationships, the first question that gets asked is does the deceased have a spouse? And if they have a spouse, then there's a formula of how much the spouse receives. The next question is, does the deceased have children? And if the answer is yes, the children may receive something. And then it's based on bloodline, effectively, of who controls your estate, and then further out, who will receive your estate. But the thing that must be remembered here is that it's on bloodline. So it'll work out from your parents, uncles and aunties and cousins. But if it gets out to your cousins and there's still no one in your family alive, the state government will probably receive your estate. So we don't want that. But the other people who are forgotten, if someone dies without a will, what we know as dying intestate, what happens is the people who miss out are your friends. They cannot receive when you die without a will, and charities. So you have no say at all of who receives from your estate. So that is easily fixed by making a will. So if you'd like to leave something to your friends, if you'd like to leave something to a charity, make a will. Easily solved.
Fantastic. No, very good advice. And when it comes to a will, who should I appoint as my executor?
Good question. So there's probably three issues at play here. We don't need to get too confused with everything, but we look at the legalities. So what is the legal things that an executor does? So we won't get too bogged down on that. But one of the legal points are that the executors must act unanimously if the will doesn't state that. So if there's two or more executors, they must be unanimous in their decisions. It's a great check and balance to have multiple executors. And then the other two things that we focus on as lawyers are the practicalities. Is it practical for these people to act as your executors? Are they overseas? It may not be practical. And the personalities. Do they have their own affairs in order? So an executor effectively stands in the shoes of the deceased and they finalise the affairs of the deceased. So things like that you may not have turned your mind to, like paying out the last power bill, shutting down Netflix, paying out any loans or debts, applying to the Supreme Court for probate, administering the estate by what the will states, if there is a will. So it's a very important job, but the big question that you must ask is, do I trust my executor? And if the answer is no, that person's probably not suitable to be your executor. So if you don't have anyone that you trust, you may look at someone like your lawyer, like your accountant, or like state trustees, equity trustees, a trustee company. They're not cheap, of course. They charge any of the professionals, but that is something that you may have to consider if you can't think of anyone.
Fantastic. And I know we didn't sort of discuss this ahead of time, but something I'm quite curious about is how long would the role of executor approximately last? How long would it sort of take from probate through to final distribution?
Yeah, so usual circumstances, usually in the months just after someone's died, there's an application to the Supreme Court for probate, depending on what the assets are. Usually there's a 6-month wait after probate has been granted to make sure that there are no family provision claims against the estate. No one is making a claim for further provision. Okay, so say, oh, I haven't been provided properly. So the executors wait that 6 months. That's how long someone has to make a claim. And then once the 6 months is up, generally, if the assets have all been called in, liquidated, they can be distributed according to the will. But it's a bit long. How long is a piece of string, Christy? It depends on what the assets in the estate are. If the deceased has left their affairs in a mess or not. If there's assets that are international, yeah, it just depends. Okay, you'd probably ask your lawyer for specifics on the situation.
So every situation's different, isn't it?
Every situation is different, of course.
Okay, nice one. And speaking of assets, how do I ensure that they are distributed according to my wishes?
And it sort of follows on from that point we were making about the executors. It's simply having your affairs in order, so the executors can administer your estate quite simply. Okay, so do you trust the executors? That's probably the first question. If they're a touch dodgy, they may not be suitable to be your executor. So good, honest people that you can trust. But also it is very helpful to the executors to have your estate in a situation where it's easy to administer. So have everything up to date with your accounts. So have your taxes up to date. If you haven't paid your taxes for a few years, it may be time to get on top of those. It also is helpful to have a financial planner. They may have, they'll help you get your affairs in order if you have things in a mess. Shares that you've forgotten about, bank accounts you've forgotten about, things like that. If they're in order, they're easier. It's easier for the executors to administer the estate.
Fantastic. Very sage advice. Thank you. Now, one of the questions that we do hear a lot, we hear asked very often, Martin, is what happens to my super in the event of my death?
Good question. Put simply, the fund will never keep the funds. It's always going to be paid out to what's called beneficiaries. So it's going to be paid out, but that's a great lead into the next question. But the short and the long, it will be paid out.
Fantastic. And so, as we say, leading into this next question, does a will cover where my super is paid to?
No, it doesn't. And I don't want to step on Mark's shoes here, but super is considered a non-estate asset. So if a person has a will, Well, it doesn't actually cover their super.
Okay,
So
so
your will, or Mark can jump in, but the will covers your estate assets, but the super is considered a non-estate asset. And that's where, I don't want to jump the gun, but making a beneficiary nomination is incredibly important for your super.
fantastic. And can you please tell us more about that? Because I think we've probably heard those words spoken or we've read them somewhere, but maybe we don't actually understand the severity of them when it comes to estate planning.
Yep. So if you want your wishes carried out when it comes to your super, you can put in place a type of nomination. It's called a binding death benefit nomination. So this is a nomination. The easiest way I think about it's like a will for your super, but a proper will for your super. So a binding death benefit nomination, it legally binds the super fund, so they have to follow that nomination. So it gives you that peace of mind that my super will be distributed to those who I want it to go to.
Fantastic. And how does someone go about doing that?
Yep. So binding nominations, one of the only things still that has, well, wills as well, and those type of things. But when it comes to super, has to be done via a form. So it's a really simple form for all funds. Our form at Hester is generally a 2-pager. The first page, popping in your member number, your details, and then you're putting in the details of your beneficiaries, name, email, mobile number. Also letting us know there's like check boxes. What is the beneficiary's relationship to you? So there's options for spouse or de facto. There's an option for child. There's an option for an interdependent or financial dependent. And you can also nominate your legal personal representative, which, as Mark said, is the executor or administrator of your estate. So I often have meetings with our members. They say, well, I'm not married. I don't have children. How can I have a binding nomination? Well, you can via your legal personal representative, which basically means it'll be paid to your estate and distributed through the will that way.
But something that we didn't discuss actually earlier, and I'm curious about, could you nominate a charity or charities through that binding nomination?
No, you can't because you've got to nominate one of that, basically the 4 categories or relationship to you. So spouse de facto, children of any age, financial dependent or interdependent, they're both together, or legal personal representative. But if you do it via your legal personal representative, make provisions in the will, and then it can be distributed that way.
Fantastic. Thank you. And then curious about tax on the super death benefit. Can you tell us more about that, please?
Certainly can. I'll just go back a second. Now, a lot of people, they think, yes, I've done a beneficiary nomination of my super, and this is where super can be annoyingly complicated. There are 2 different types of beneficiary nominations available. So I talked about the one that's legally binding, always a good idea because it gives you certainty where things are going to go. The other type is a non-binding nomination. Now, non-binding means it can help or guide the super fund where you want the benefits paid to, but it's all in the wording. Non-binding means it's not legally binding on the super fund. So it does still leave discretion up to the fund as to where any benefits are going to be paid to. So I'd sort of say it might be the equivalent of a newsagent will, where it may or may not be, that good. But essentially, a non-binding nomination, it's almost like not having a nomination at all because you are leaving discretion up to the fund. Now, it doesn't mean it wouldn't end up who you've nominated, but before any benefits are paid out, the fund basically has to do its due diligence and do an investigation. Who could we pay it to under law? And under law, funds will always look to pay to a group of people called super dependents, spouse or de facto, children of any age, financial dependence, or some of the interdependency relationship. So they would always look at it that way. That was going back a little bit there, but tax on super. Now, they do say in Australia there are no death taxes, but that only applies to your estate assets. And super being a non-estate asset, there are different rules. Now, if it is paid to a spouse or de facto, children under the age of 18, or what's classed as a financial dependent or interdependent, they get it tax-free. However, if it's being passed to adult children, or it could be relatives, charities, whatever it may be, the super death benefit tax is 15% plus 2% Medicare. So 17%.
So that's a significant amount of most people's superannuation, isn't it?
It can be considerable. There are things you can do about it, though. I think we've got time for me to talk a little bit
Absolutely.
about this. So, for those who it is important to try and maximise what beneficiaries get from their super in the event of death, there is strategies that you can get advice on to maximise that benefit. I won't go into the real ins and outs of it, but if that's important to you, especially for those who are HESTA members, you get in touch and you can get advice around that. Or you may talk to an estate planning professional as well, like Mark. But there are certainly strategies that you can do to maximise what your beneficiaries get.
Wonderful. Thank you so much. And then, so speaking of beneficiaries and ensuring that they are being taken care of, so Mark, how can I make sure that my children are being taken care of after my passing? And do I need a testamentary trust set up in my will to ensure my wishes are carried out in regards to my beneficiaries?
Good question, Christy. And there's a number of ways you can look after your children through your will. So the first one quite clearly is if your children are under the age of 18, it's a good idea to think about what is going to happen if they don't have a parent or a guardian to look after them. So if you and your spouse, or maybe you're a sole parent, if you pass, who are you going to nominate as the testamentary guardian in your will? Okay, so who is going to be making day-to-day decisions? Now, it's probably a good idea to ask the people whether they would like to be the testamentary guardian. As much as you love your children, the people you'd like to nominate may not want to do the job after you've gone. So have that discussion with the people you're thinking about. And then have a discussion with your estate planning lawyer, and they'll draft a clause to take care of your children with it, not necessarily financially, but with the day-to-day decisions of looking after your children. Who do you want to do that? Now, you mentioned, Christy, testamentary trust wills. I could be here all day talking about testamentary trust wills. I'm a great believer of them. Now, if you have an estate more than 500,000, I think that's a pretty good line to have in the sand. You really need to have a chat to your estate planning lawyer. So what the testamentary trust essentially is doing is quarantining the inheritance in a trust. So if the children are under 18, someone else can look after the children. So a testamentary trust will is really dependent on the estate planning lawyer who is drafting them. They're all different. They're not uniform. What can be called a testamentary trust can be very basic, or you can have something that's very complex on the other extreme. The testamentary trusts are a great way of minimizing tax for your beneficiaries. Okay, I'm not here to give tax advice, but it's a discussion you need to have with an estate planning lawyer about whether it's worth it for you in your situation to have. Even better, it's great for asset protection. So the inheritance can be protected if you leave your estate to your children. It can prevent a family property settlement if your children go through divorce. It puts the inheritance beyond the family court, okay? However, it depends on how well that testamentary trust will is drafted. But yeah, without boring everyone for too long, it really is a conversation that you need to have with your estate planning lawyer. Some lawyers are better than others at drafting testamentary trust wills. Only a lawyer should be drafting a testamentary trust will. It's beyond anyone else's capabilities in all due respect. You need to consider trustee law, family law, bankruptcy law, estate law, of course. There's a lot of consideration that needs to go into a testamentary trust will, but they do protect the estate from predators and creditors, and it keeps the inheritance not just for the next generation, but it keeps it in the bloodline for generations in the future. Yeah, I don't want to labour the fact too long, Christy, but that they're fantastic for families who want to maintain wealth and a legacy for generations.
Fantastic. And I think that's the key, isn't it? It's maintaining that legacy. It's passing on your values through that protected inheritance, which is absolutely key. So
and more than likely the trust will have your name on it. So when grandchildren or great grandchildren have control of that, yeah, when you die, the name of your name will be on that trust for generations.
and they last for up to 80 years, I believe.
Correct. They can last up to 80 years. They have to vest after 80 years. Maybe your trustees might get sick of administering the estate. It may be depleted. It may be worthwhile, winding the estate up before then.
Wonderful. Thanks, Mark. And how often should I review or update my will? Yeah, can you share your insights on that?
Yeah, it's a good idea to have your will reviewed every 3 to 4 to 5 years, I guess, in that sort of time period. But it is very dependent on the situation. So if there's a birth, death, or marriage, for example, that may change the situation. So if you have an executor appointed and your executor dies, it's a good idea to update your will with another executor. You may have a reserve executor in place anyway. Well, you can move them up to the first executor and put in a substitute executor in your new will. Maybe a beneficiary has died. Maybe you've got married. That will void your previous will. So if you get married, update your will. Maybe you've got some children of your own. Maybe you've got some new grandchildren. You want to provide for them in your will with a specific gift. But it's a good idea to contact your lawyer who's drafted your will every probably 3 to 5 years. In that time period, just say, can you please review my will? My situation's changed. Yeah, and the conversation will go from there. Also, when people change addresses, I get contacted quite a lot. If people change addresses, there's no urgency to update your will. It's the same person. However, when you update your will the next time in that 3 to 5 year period, you put the new address in then. The address is just to identify the person. It's not there as a be all and end all, and the clause will fail because they've changed their address.
Fantastic. I was actually going to ask that exact question. Do you need to update your address? So there we go. You've done that beautifully. Thank you. And then the final question that we've sort of pre-selected, I guess, in terms of the most common estate planning questions that you've experienced and Martin's experienced in both of your careers. So Mark, can I exclude someone from my will?
I guess the simplest way to explain this is it's a don't try this at home kind of scenario. Okay, if you're going to leave someone who has a dependency on you, it's a good idea to seek some legal advice. So in short, yes, you can exclude someone from your will. However, if it's someone like your spouse, seek legal advice. If you're going to exclude them from your will, they'll most likely have a family provision claim. So you don't want someone challenging your will after you die. What will happen is if there's a claim against your will, there won't be one lawyer fighting, there'll be 2 lawyers fighting over your will, maybe 3 lawyers, okay? So acting for the beneficiaries or the potential beneficiaries of your estate. It's not a cheap exercise. It's best to put everything in order now, seek the advice, make your will, you can't make them watertight, but mitigate the chances of someone making a challenge against your estate. So if you're going to exclude a family member from your will, seek advice. Don't do it with a do-it-at-home will kit, because if you do it with a do-it-at-home will kit, do-it-yourself will kit, or internet will, whatever you want to call them, that increases the chances of someone challenging your will, possibly 5-10-fold. I don't know what the numbers are, but if an estate litigation lawyer sees someone or they're acting for someone who's been excluded for the will from the will, and it's a do-it-yourself will, there's a fair chance it's going to be challenged, or more likely to be challenged than a lawyer drafted will.
And am I right in thinking, Mark, that if the will is challenged, then the estate's actually paying to defend the wishes of the testor in a court situation?
Correct. It's most likely going to be the estate that's going to be footing the challenge as well. Okay, if it's a reasonable challenge, most challenges are settled at mediation. Okay, but you don't want your family having to challenge your will, because it's a terrible situation. Family members will most likely never speak to each other again. It's a hand grenade into the family after you've died. It's maybe considered a little bit selfish without seeking that legal advice first to exclude someone from a will. So think long and hard. If you are going to exclude someone from your will, seek legal advice. I don't recommend going down the path of excluding someone without legal advice.
Well, thank you. And we have got actually time for a couple of questions that have come through, which is great.
Great. Fill your boots up.
Philip's got two here. So are executors paid, and how much should a will cost to get drafted?
Good question. Executors are usually acting voluntarily. Okay. However, professional executors can be paid. So if you appoint your lawyer, your accountant, your financial planner, they can be paid a reasonable rate, or their usual reasonable rate. That could be $400 to $500 an hour, could be $600 an hour, depending on on their experience. The usual cost to draft a will, it depends. Okay, anywhere it depends on the law firm drafting it, really, and what the way they charge. Some charge by the hour, some charge a fixed fee. Now, just as an example, okay, for me myself, I'm $1,000 plus GST. That's for a single. That's a will, enduring power of attorney, appointment of medical treatment decision maker, an advanced care directive template. For a couple, it's $1,500 GST. That's a standard will. And then the testamentary trust wills, there are $3,000 plus GST for a single, and then for a couple, $4,500 plus GST. That's not a sales pitch. That's just an example of what the fees are. Okay, so my view would be, if you're cost sensitive, feel free to price around. Estate planning lawyers, they're pretty busy, but price around if that affects you. I would just remind you get what you pay for sometimes in life, don't you? So yeah, just
absolutely
ring around.
And I think too, I think the thing we have to all remember is it's a small cost now to ensure that our wishes are carried out as we would like them to be, when it's no longer in our control. So I think that's something that's really relevant.
And the point I would make, Christy, is if you've got estate litigation lawyers fighting amongst themselves, it's probably about $25,000 for the day to sit around and for them to fight at mediation. Could be 30, depends. Okay, so very small in the scale of things. The cost of a well-drafted will, it may seem expensive on first blush, but the returns on a testamentary trust will, from asset protection. So if it protects your child from going through a divorce, protects that inheritance. If they've got $1 million inheritance, it could be $500,000 saved by your son and daughter-in-law not getting their hands on the inheritance that you've given to your child.
Absolutely. No, thank you. And we are at the end of time, but I do have a question for you, Martin, just because I think it's very relevant. Peter is asking, where do I apply for the defined beneficiary nomination?
Well, if it's through I'd say APRA-regulated fund, which is like your industry funds like Hester, it can be the retail ones. I mean, it's just done via a form. That's all it is. So two-pager. Didn't mention earlier, it's got to be signed and dated in the presence of two witnesses, the binding nomination form. There are some non-lapsing types. Hester's one you've got to renew every 3 years. If you've got a self-managed super fund, I think I saw that in the Q&A box. That's where you talk to your accountant or financial planner around that.
Fantastic, wonderful. Well, look, we will wrap things up because it does bring us to the end of our webinar. So Martin and Mark, thank you so much for sharing your expert knowledge with us and with our supporters. And I'm sure I speak for everybody here when I say that this has been incredibly informative and very, very insightful. So thank you very much.
No worries.
Thank you. Thanks, Christy. Thanks,
Right,
Martin.
and thank you everyone who attended today. It was wonderful to have you here. And as I mentioned earlier, we will be sending out a recording and it will also be available on the Foundation website. So thank you once again. Thank you for your support of St. Vincent's and we will see you the next time. Take care.